Welcome to the debate. Our discussion today centers on a resource that's, well, probably on the desk of every lawyer in America, Black's Law Dictionary, or BLD. Now, the source material is perfectly clear on one thing. Formally, it's a secondary source. It isn't the law itself.
Right. And that distinction is, I think, where the whole debate really starts.
Exactly. So the central question we have to tackle is this. Does Black's Law Dictionary's unmatched scholarly rigor and its position as, quote, the most widely cited law book in the world, give it a functional authority in legal interpretation that, transcends its formal status?
And that word functional is key.
It is. I'll be arguing that the dictionary's meticulous scholarship and its practical utility make it functionally essential for clarity and persuasive argument in modern law.
And I'll be taking the opposing view. I think its non-binding status is an intrinsic, unavoidable limitation. Relying on it is inherently risky because the real sources of law, the primary authorities, have to be the final word, even if they contradict a dictionary definition.
Okay, well, I see why you'd think that, but let me offer a different perspective, one that's really rooted in necessity. BLD is, I'd argue, the indispensable authority for defining specialized legal terms, precisely because law is a living, changing language. The massive editorial evolution it underwent with Brian A. Garner, starting with the 7th edition, it fundamentally changed what the book is.
And that is a critical point. You have to acknowledge that Garner, who is, rightly seen as the world's leading legal lexicographer, brought a level of rigor that just wasn't there before.
Absolutely. Garner and his team consciously moved away from just compiling little judicial snippets, which, often led to these circular, poorly defined terms. And instead they started incorporating substantive expertise from legal treatises and scholars. This whole process dramatically increased what the material calls its scholarly reliability. So when laws are vague, or when judges are searching for textual clarity, this level of scholarly vetting provides really the strongest foundation available. And the result is a reference that now defines over 70,000 law-related words and phrases. It provides that necessary common denominator for an evolving legal language. We see this with them constantly adding modern terms like deepfake or zombie foreclosure. Its widespread citation, it's cited more than any other legal reference book. That's not just a habit. It's evidence of its necessary functional authority in ensuring precision and a shared current understanding.
I'm sorry, but I just don't buy that. I don't see how the frequency of citation translates into a functional authority that can supersede primary sources. Let me tell you why. The material's explicit about this. Legal dictionaries are secondary sources. They are, at best, materials about the law, but they do not itself establish it.
But no one is arguing that BLD is the law.
Well, the real sources of compulsion, the primary authorities, are the Constitution, statutes, case law, and formal rules. Relying on a dictionary definition as if it's binding law is to, I think, fundamentally misunderstand the entire legal hierarchy. A definition that might seem perfectly accurate today could be completely superseded by a binding precedent tomorrow, rendering the dictionary not just useless, but actually worse, misleading.
Well, we're talking about functional authority, not binding precedent. The functional necessity emerges when primary sources use a term without defining it. That forces a court to find the most authoritative explanation. The advocate has to provide the judge with the clearest, most scholarly, and most precise definition available, and that, today, is BLD.
But seeking clarity through a dictionary definition, by its very nature, risks ignoring the crucial legal framework provided by that primary source. Take a term like heir or issue. The true meaning is often dictated by a governing state statute on intestacy or by the common law history of property rights, and that's regardless of what BLD provides as a general definition. If a lawyer relies only on that non-contextual definition, they risk substituting a general scholarly view for a specific legal command, and that can lead to the wrong outcome.
That's an interesting point, though. I would frame it differently. I'd focus on why the modern lexicography elevates the dictionary status. The contemporary editions of BLD are works of original scholarship, really designed specifically to serve the interpretive needs of the law. They're not just random collections of quotes anymore.
Okay, could you elaborate on that methodological change?
Certainly. Garner's approach prioritizes precision
and utility for the person using it. He introduced this structured definition framework. He uses bullets to separate the concise definition, the BBS, or before the bullet stuff, from the detailed encyclopedic information, which is the ABS, or after the bullet stuff. And this structure allows lawyers and judges to quickly grasp the core meaning while still providing the option for deeper contextual insight. But why does that methodological sophistication actually matter in a court of law? Because it fills the vacuum that occurs when the primary law is silent. An advocate in a legal brief needs to present a definition that reflects the highest level of legal consensus. And BLD provides this by, for example, intentionally quoting substantive experts, like citing Douglas Laycock on the irreparable injury rule, rather than just relying on some ambiguous intermediate court citation, like the older editions often did. This ensures the definition reflects the most informed, scholarly legal understanding. And the fact that the editors fixed an embarrassing typo like vitiligate, which persisted for 89 years, well, that's a small but powerful symbol of this new, almost scientific commitment to accuracy that practitioners depend on.
I see the commitment to accuracy, but the rigor of the lexicography does not in fact change the legal hierarchy. Courts rely on legislative intent, on established rules of construction, and on stare decisis, adherence to precedent, not on the preferences of lexicographers. And while the Supreme Court's use of dictionaries has, as the material notes, rocketed since the 50s, that growth is often tied to interpreting non-technical words of common speech, where the court is just seeking the ordinary public meaning of a term in a statute. For technical legal terms, sure, they might cite BLD, but it's cited as persuasive authority or as a reference, not as a source of legal compulsion.
But if we accept the rise of textualism, where the focus is strictly on the plain meaning of the text, doesn't the most meticulously vetted definition gain functional weight? If a statute doesn't define proximate cause, the court is functionally compelled to find the best definition out there. Ignoring the most scholarly source would seem almost like judicial negligence in that kind of scenario.
I just come at it from a different way. Legal meaning is derived from jurisprudence, from context, not from a definition in isolation. Relying on definitions that are, quote, by nature severed from context is just inherently flawed. I mean, look at the sheer difficulty of interpreting a single word like any. The Supreme Court, within just a 2-year window, construed the word any both narrowly and expansively, depending on the legal context of the statute they were looking at.
Right, in the Dolan and Alley cases?
Exactly. That shows that no dictionary definition, no matter how sophisticated, could possibly predict or substitute for the meaning that's derived from the interplay of legislative purpose and established case law.
I'd say the dictionary provides the starting line, the common language for that contextual analysis. When legal language is continually evolving, as Thomson Reuters says, a reference that captures this living language is a necessary utility. I mean, terms like ghost gun and shadow docket were just added because they are actively relevant to legal practice right now. BLD is essentially acting as a real-time linguistic barometer for the profession, which, to me, makes it indispensable.
And that expanded coverage is undeniable.
Right. It's added thousands of new terms, specialized subentries. It went from 5 to 15 subentries for interest rate alone. For legal professionals, this resource helps foster a common understanding of new complex concepts. And furthermore, the Blue Book itself, the ultimate arbiter of legal citation, provides specific guidelines, Rule B 15.1, for how to properly cite BLD. This institutional recognition from the entire legal establishment proves it's a recognized, necessary component of legal advocacy.
I'm sorry, but I just don't buy that at all. The presence of a citation rule merely instructs how to reference a secondary source. It doesn't elevate it on the hierarchy of authority. We have rules for citing treatises and law review articles too. They're all secondary. Citing the Blue Book to prove authority is, I think, confusing form with substance.
But it shows it's structurally necessary for crafting a professional argument.
But let's focus on the risk that's inherent in this claimed functional necessity, which is definitional flux. The source material explicitly warns that definitions can and do change between editions. An advocate faces a serious professional dilemma when a once helpful legal definition in Blacks becomes less helpful in a subsequent edition.
Well, that uncertainty is just a reflection of the evolving law, not a flaw in the dictionary. The dictionary is just reporting the most current, accepted scholarly view of the term.
If the law itself is fluid, shouldn't the definition reflect that fluidity?
No, because the risk of relying on a non-binding definition that's subject to change based on an editor's decision is just too high, when, as the material says, real law comes from that real legal authority. A judge in 2024 has to interpret a statute from 1980, and the BLD definition from 1980 might be far more relevant to legislative intent than the updated scholarly definition from today. Using the wrong one can lead to a substantively wrong outcome. This tool is for interpretation, yes, but it must be used with due care and never as a standalone basis for a legal claim.
I would argue that due care demands that the advocate use the most precise language available. When primary authority is silent, the highest form of scholarly expertise is the next best choice. To simply ignore the resource cited most often by the very courts you were arguing before is, I think, to engage in ineffective advocacy. The proliferation of new terms and the need for precision makes BLD a tool that, functionally, we cannot practice law without.
Look, we can agree that BLD is an extraordinary reference tool, but we fundamentally disagree on the functional impact of its scholarly depth. Its utility is undeniable. Its authority in compelling a judicial outcome is minimal, and the risk of its misuse is substantial. It is a guide to language, not a source of command.
So we've explored this central tension regarding Black's Law Dictionary, its formal status as a secondary, non-binding authority versus its acknowledged position as the most scholarly and most frequently cited legal reference in the United States. A real paradox. It is. I've highlighted how the dictionary's methodological improvements under Brian Garner and its sheer comprehensive scope make it an indispensable tool for achieving precision and a common vocabulary in an evolving field. The argument is that this scholarly commitment elevates it to a position of functional necessity.
And I've emphasized that no amount of scholarship or lexicographical expertise can override the clear hierarchy of legal sources. The Constitution, statutes, and case law are the binding authority. The dictionary is a tool for explanation, and its use outside of strict subordination to primary sources risks substituting established precedent with a non-contextual definition.
Ultimately, the source material really compels us to distinguish clearly between the authority that comes from expertise and the authority that comes from the formal structures of law. Understanding that distinction is, I think, vital for navigating the landscape of legal interpretation.
Agreed. And there is certainly more to explore in the material regarding that intersection of language, authority, and the law.